This is not the first time to hear your name on Extreme Media UK. Subscribing, liking, share, commenting. Guys, I'm not begging. I'm asking, I'm requesting. Understand? And we are Ugandans. And if you're not interested in begging, don't just shut up. Understand? Hey, I'm not. If it's not you to. If you don't want to do something, don't. It's not by force. I'm very interested. You make it. Kusima expeditious. Bade ndabo bapoeri. Najule kakati. Wama share Airtel number. Wama thank you David Commander. Wama thank you. That's the Airtel 07429 44256. David Kamande, that's the Airtel number. Thank you for appreciating. That's the Airtel number. It's in the names of Nicholas Jogeza. Nicholas Jogeza. Yeah, and the court is almost coming. Ghana is. Hope you've got it. Hope you got the number. Okay, thank you. Thank you, man. I'm afraid of sir. Thank you.
I don't know the message of this, and it's another administration. So I didn't talk to the commander, I don't know if they have them, it's not they can. I don't have power or uniform. Uniform is given to soldiers. So they say don't put on uniform which is given by the institution. You see that it's a council there, but you don't see it. Maybe it has not been given. Listen to ruling on whether they amend on whether amended the charge sheet or not. This court, after listening to the application by counsel, ran the counsel for the state, amended the charges against the accused person by adding another suspect, and the objections to the amendment raised by the land councils for the accused persons. The court has considered the submissions of both counsel and the relevant laws relating to the amendment charges, has deliberated with the profession and pronounced itself as follows. 1. That the amendment can be made in the course of the proceedings at any stage as long as this court hereby allows the application amended the charges as so
President, amesema kwa mkono just.
The language of court is English. Each of you is going to tell court the language is going to use. I'm starting with you, Besigye. Which language?
I kindly request that we have made a copy of the charges amendment. Because when once there have been amendments, ideally the officer preparing the charge and the court will sign, then it's a complete judgment which is complete. That is the one, then we start our questions because we do not have that option. Advice the council at that stage. We may advise them what we see and they say we are here, we say it's that. The import is that so that we know what is coming, so that they are advised before they take. We kindly request because we haven't seen the amendment, we don't know that it's there, and from what I can see of this long side, I think my colleague, the court official, is reading the table, not the amended charge.
the transcript will be read, but the court clerk, I think, will bring another thing in the judge.
Proceeding upon the Besigye, the language of court. The language of court is English. No court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I have indicated that I can communicate in English.
A1, English, sir. Afandola, which language? And Ra, English. David Tare, Chirangwe.
Yes. You are number 2.
In Amen, a soldier must follow his fellow soldier. David Tare, English. And Besigye, and David Tare, the lawyers, known. But Captain Ola, you have the right to be with lawyers. And we have the lawyer of the army, and Captain Sobuga. It is your choice. If you have your money, you can go and pay a lawyer from outside. But Sobuga and his team, they are paid by the state. So, do you want to use a Suga, the lawyer of the state, or you want to hire your own lawyers?
I would intend to get other lawyers, but for the meantime, you can go.
For the moment, we hope to use Captain Suga. Lastly, this is the panel of the judges who will hear your case. Look at them carefully. If you have any objection to any of the members, you will say so. But if they want to reason why, I'm starting with you, and the rest. If you have any objection to any of the members?
I don't know who the members are. And I know who they are before I raise an objection otherwise.
They are here, look at them.
Mr. Chairman, this may go to the issue of names, ranks, introducing the panel. Really, I do think that is where we are. Because you can't just say, look at them. What if you don't know someone? The requirement is actually to the names be read out and all that.
But we have been informed that the panel is beyond the ones who are sitting. So we know who all of them are.
And then we can provide the list of the panel to your defense lawyers.
The question I've been asked is whether I object or not. I cannot object because I don't know.
I think so, Lord, you can start, you say, the chairman, and all other members. Help yourself.
That's what we are talking about. Brigadier General Robert Freeman Mugabe, Chair General of Commercial.
Major Richard, I'm a member.
Captain Abdallah Sajara, member. Warrant Officer 1, Mr. Robert Akyaali, member.
Major Sarasoko, member.
Lieutenant Colonel Sam Tugura, political officer, member.
Captain Ryan Akyaali, member.
Warrant Officer 1, we are both department.
Captain Christina Sayuni, member.
What is this? I didn't hear. What is this?
Warrant Officer 1, we are both smart men.
Now, question is back to you. We have any objection, any of the members who have introduced themselves?
Yes, yes, that.
We have any objection to any of the members and reserved members who have introduced themselves?
No.
Has no objection, anyone, sir? Captain Nora, we have any objection to any of the members who have introduced themselves? Captain Nora has no objection. Okay, do you have any objection to the members who have introduced themselves to you? No. Rotary has no objection to the panel.
Adam is starting. Adam is starting.
The Republic of Uganda, Uganda People's Defense Forces, the General Court Martial, Foreign and Martin Kampala. Criminal case number EPDF /040 of 2024. Dated today. Amended charge sheet. Uganda versus A1, Article 1274, 3, Captain Dennis Kora. Mr. Officer attached to power to the date, a person subject to A2 Article 0098, Colonel Shad Dr. Chiza arrest, made adult London of South Mind, 67 years, resident of Kasanga Town and the sub-count, answer and dispatch of the district capacity to Road, the water section 117, section 1, A3 Hajj, retired, male adult children of some money, 65 years, resident of Mukundu Parish, marking the Southern sub-county, county, sub-district, and person subject to Road, the right of section 117, subsection 1, I of the PDF Act the ambulance a statement of offense in count 1. Offense is relating to security control section 128, subsection 1F, the PDF Act the ambulance particulars of offense. Captain Dennis Kora, Colonel died of Dr. Chiza and had to be retired between February 2023 and November 2024, while in the cities to which Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala metropolitan in Uganda held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to increase the security of the defense forces. Captain Dennis Kora, have you had understood the charge that you come to us?
Yes, Your Honor.
Do you accept the don't accept?
I simply without me see passing on to proceed. I've just got the instructions at the back to represent Captain Ola. I'm only privy to the amendment now. I humbly request that I interact with him and guide him Thereafter, I shall formalize the instructions, if you please.
How long?
Just a few minutes. About 2 minutes. Not 2 minutes. Fellow Chairman, women officers.
Once again, Captain Dennis, we had an secretary.
Yes, of course.
You accept, you don't accept.
I don't accept.
We have not read the content. I cannot regret Dr. Dennis, you have not understood the charge to come.
I am hurt and I have issues with the charges which my lawyers present.
Sir Chairman, we have objections to be taken, grounded on regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking the plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with territorial jurisdiction of the Supreme Court. And there is a ruling which is pending before the Supreme Court, which is not delivered. But this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and court, this honorable court martial has not pronounced itself on the matter. So to be a violation of regulation 23 for the accused person to proceed and make a plea before the ruling is delivered.
Are you not taking this counsel? Are you not taking this time? It is really taking. You can say yes or no. Then we can start from there.
Mr. Chairman, the rule is before pleading to the charge, the accused may offer a plea to the jurisdiction. That is the rule And this is what I'm quoting. And oftentimes these court martials reminded us to abide by these rules. And the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate that advice for this honorable court martial. That it's within the accused's right not to take a plea until the ruling is delivered on the delivery.
I'm reminding the Council of Power that the accused himself mentioned that objection. I'm the one talking. Objection. No, you cannot object when I'm talking. Objection.
Can you listen and be efficient? What is
you have not listened to anything.
You have not listened what that is saying. Now what are you objecting? You don't even listen to what is saying.
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar can avenge the ruling that was raised objecting to jurisdiction by this court. Just to remind you, you read the ruling and when it was delivered. And we proceed.
Mr. Chairman, objection. Please, hold on and you wait for the jurisdiction. That one will not stop you from submitting the one you must submit. But first, listen.
My Lord, Mr. Commission, proceed with the ruling that public of the government and the resources in the Geo Court Master for the continuity. Criminal case number 58, sent to your portion, President Paul. Uganda, presented by the prosecutor versus A1, ROB 30098, Colonel retired Dr. Kiza Lisi. A2, Ajabedi Tale, accused person. Ruling on application made by counsel years in court.
There was a ruling raised on the jurisdiction of the court. Not the one of the court. The one of the court is not yet.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it, then you go to consult your friend.
Why are you standing for get that ruling register so that you
ruling wanebalakidde.
Thank you.
Because the court wanted it, it didn't want it. Now we are all the judge wanted to prosecute I think, sir, for me, as judge of this court, the registrar is in under my office. I am written it is here. I have not written it now. So the ruling was pronounced by the court. It is that you raise it himself for the one. No, it shouldn't be a point of saying that you are raising it now. What do you believe?
Oh, sorry.
If you don't have the right to say, you got to make it.
My Lord, on 20th November 2024, A1, by then was retired Colonel Besigye. You objected to all the court members.
I don't understand. What? I thought you were supposed to do the last.
Objected to all the court panel and jurisdiction. Even the A2, who is now Besigye, raised the same objection. Chair guided that the accused have to give reasons for the objection as regards court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of military. I believe I should be tried by civilian court. A2 stated the same. J guided that state had to give a reply to the objections. State replied as follows. It captures the concerns of contradiction. Hopeful, the ruling had this background. States have admitted that the object is one, the objection is one, and the reply they stated as follows. That the enabling law, which is section 117, applies for the accused person, that is A1 and A2, and then what were referred to. He also proceeded as said and informed the court that he did not even know the lawyers that were representing the accused person. Then J guided that the court had to close for the explanation and make the ruling. Counsel Kwaku submitted that they had no opportunity to meet the accused persons. To hear their story and get full instructions. He asserted that lawyers as a practice may proceed with instructions. He proceeded to report that A1, as then was Dr. Kiza Besigye, and his colleague by then was A2.
I'm always in the sport. I want the house. What came and gave the rules, and I have the ruling here. The court said they are subject to military law under section 117T and H of the Indian Statute. That was the ruling of court.
Mr. Chairman, the judge advocates by law is not a record keeper. We cannot assume the role of the registrar with respect, and therefore the registrar is under your office, but you cannot, the law does not allow you to come to court and be an advisor as well as a record keeper.
I'm the one who supervises the record.
My Lord, the ruling prepared is that after 5 minutes deliberation.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons who were two at the time regarding the instructions of counsel to receive the ruling. It might be recalled, Mr. Chairman, that when court asked or pointed out to my senior colleague, Mr. Kwako, why there should be an adjournment, we did point out that we who were present, myself and Mr. Katuba, in the absence of Mr. Kalibara, who were counsel on the record at the time, were not in court when those objections were made. When we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Kiza. So there was no handing down of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. When the judge advocate insists that his office has the ruling which has not been handed down to the court, Mr. Chairman, points to the impartiality of court and any other person who follows these proceedings on TikTok and who will only see this caption might think that it is the office of the JA which perhaps writes the rulings for the court. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our uncalled. Not recall ruling who has no ruling, and yet the advisor of the court insists that for him he has the ruling. It is again, Mr. Chairman, we did remind ourselves that we as lawyers may understand the omissions, but to someone who is in the dock, who is a businessman, a doctor, a gallant soldier, doesn't understand this process, might think that this is a prearranged session. It is a little concerning again, we didn't want because it will be the third time. Sometimes, rather than going what we are going through, perhaps the court to retreat a little, just to put its house in order, because now we are fully grown. It doesn't appear quite nice.
My Lord and members, make this very clear. On the first day, the accused persons were not presented, and that's when he raised the objection to Nixon. And on the same day also, Lord Mayor, as then was now his counsel, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background what happened in court, and then another one you haven't given also to read. So I prefer to proceed with the one on jurisdiction that was raised by the persons at the time who were not represented. Citing section 117 of the UPDF Act Cap 330, court ruled that this honorable court has jurisdiction and has jurisdiction over the accused persons since they are all subject to trial by virtue of the same section and dependent there. And we proceeded and led the charges the accused persons, to which they all pleaded not guilty. And then that's when yes, with due respect, nobody was not cancelled, had no instructions, proceeded and also raised some objections as pertaining to the charges. That's what we have.
I think I have vindicated. Yes, because my study was the one of the notice for. Why are you saying that I'm writing my book?
That one was finished. Let us proceed. I was counsel seat. I was asking the panel that which is arrested. Have you had understood the judgment during round one?
I have heard and I have responded, but I have objections to taking plea from this charge and requesting my lawyers to present my objections.
You are right, but at this moment I'm asking you to choose the person. If you don't accept, say not accept. If you accept, say yes, I accept.
Accept what?
There are two things. If you have had and understood, another question is, do you accept or you don't accept?
Accept what?
Help you.
Well, plead guilty or not guilty. You want me to take a plea?
He has invoked that he is objecting to taking plea. And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, counsel Elias Mkwabo raise objections on his behalf as he has asked.
Please, no, I'm not allowed anybody now to talk. Because now you are taking us backwards. It is, yes, it is a new charge. Now what you said, just now the one you are pushing for is corrected. Will he accept or he will not accept? So the issue is we have heard the charge. It is the accused person to plead guilty or not to plead guilty, and then you can start from there.
Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment of criminal charges, and also pointed out to any amendment which can be done, which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly, from looking at the amended charge dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my land friend has advised, and the JA, if we read together Regulation 283 kindly. It says, Mr. Chairman, before leading to the charge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking the plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because, according to the accused person in the dock, he has asked his lawyer to make the objection. So, my Lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear. It is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that will be part of the plea-taking process. Yet the rule requires that before that process begins, he has a right to raise objection. We humbly pray, Mr. Chairman, that we abide by this provision. We kindly request, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with Council FK. You raise your objections, let the state reply.
The humble submission of the accused persons that this honorable court-martial has got no territorial jurisdiction to entertain the charges as spelled out in the charge sheet, and it would be violation of Article 23 and 28 of the Constitution of the Republic of Uganda if you proceeded to entertain this matter. Mr. Chairman, the Constitution confines the jurisdiction of this honorable court-martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28:12, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. And also, yes, I'm coming to Article 28:7 as well, if I may be permitted to make my case. No person shall be charged with or convicted of a criminal offense which is founded on an act or commission that did not, at the time it took place, constitute a criminal offense. Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, the accused persons are alleged to have committed those offenses, particularly the allegations that they were found in possession of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28:7, those acts, the impending acts spelled out in the charge sheet, would only constitute offenses in those countries, either in Kenya, in Switzerland, or in Greece. Because, Mr. Chairman, the particulars here, they are talking, Colonel Dr. Besigye, while at Riverside apartment in Nairobi, Kenya, were found in unlawful possession of a pistol model this, which is ordinarily the monopoly of the defense forces. Mr. Chairman, this one has two limbs. One, the defense forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of Switzerland? They are not defined here. And that touches on two issues. One of jurisdiction, but also on regulations, particularly Regulation 22. Regulation 22 provides as follows. An accused may, before pleading to a charge, object to it on the grounds that it's not correct in law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is Regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in law and that it is not framed in accordance with these regulations. So this is a defective charge sheet. This is our contention, Mr. Chairman, that it's not framed in accordance with the UPDF. Rather, with the UPDF Act. It's not framed in accordance with the UPDF Act of 2005 because it is purporting to bring into the confines of this court, the jurisdiction of court, matters which relate to weapons of other countries, defense forces. It could be KDF, that is Kenya Defense Forces, or elsewhere. Because if it were a charge sheet relating to offenses under the UPDF Act, specifically they would state it here that contrary to a particular provision which talks about weapons which are ordinarily a monopoly of the UPDF. But here they are talking to contrary to defense forces. So the presumption is that this court martial has jurisdiction all over the world. That is universal jurisdiction. That whoever is found in possession of any weapon which is alleged to be a monopoly of defense forces, not UPDF, or defense forces worldwide, then this honorable court martial has got jurisdiction to deal with that. So that offense, Regulation 22, and the charge sheet becomes defective. It's not correct in law. It's not framed in accordance with the UPDF Act. Then the other limb of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and brought here. Mr. Chairman, our contention is that this honorable court martial has no jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. It's a consolidated constitutional petition number 55 and 56 of 2011. But Mr. Chairman, the reference was made to a number of decisions that have been taken by other Commonwealth countries, which we find to be persuasive. First of all, Mr. Chairman, they made the reference the case of Regina versus Horsefeld Road Magistrates Court. It's 1994, SC, Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they had to say. English common law regarding irregular apprehension of an offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Horsefeld. The earlier approach of the English courts had been that once a suspect is in lawful custody in that country and charged with an offense which that court has jurisdiction to hear, the court has no power and is not concerned to inquire into the circumstances in which he may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or kidnapped contrary to the laws of the state of reference.